when the market is doing great, interest rates can go down because our country becomes stronger. Real wages are up by $1,300 in less than 1 year under President Trump. For construction workers, wages are up $1,800. Don't forget, they were down $3,000.
I am Andrew Wilson here. Welcome, guys. What just happened is staggering. Trump has openly declared he will not comply with a direct Supreme Court order, claiming the judiciary lacks authority to constrain him.
That last night, I called for the impeachment of Donald John Trump, President of the United States of America, for threatening judges and for calling for the execution of members of Congress. If ever there was a person who ought to be impeached, it's Donald John Trump. Now, there are many people who don't want to see this happen. They don't want to vote for impeachment. Well, there were people who didn't want to cross the Edmund Pettus Bridge, but they marched on. I shall march on. I've been told that this vote will take place sometime after 1:30 today.
House Resolution 353 has been formally introduced, laying out the articles of impeachment against Donald Trump for high crimes and misdemeanors. The resolution has been referred to the House Judiciary Committee, which is where the process of investigation, testimony, and deliberation will commence. This is not a hypothetical discussion about what might happen if a president were to cross certain lines. This is an active impeachment proceeding that has already begun its journey through the legislative branch, and the momentum behind it is building because the conduct it addresses is not subject to partisan interpretation or factual dispute. Trump received a lawful order from the Supreme Court, and he has publicly refused to obey it. That is the essence of the case against him, stripped of complexity and reduced to a simple proposition that anyone can understand. Now, he also told me that he made the move because his constituents at his town halls kept asking him why he was not holding the president accountable. Now, I also spoke to Republican State Senator Jim Runstead about Donald Trump referencing the articles of impeachment at his rally last night. Yeah, when Donald Trump addressed this, it was the comical nature of this that the Democrats are trying to replay the same playbook from the 4 years when he was president, the impeachment, the Russian collusion accusations, and now even though their numbers are collapsing and imploding in the Democratic Party, they are replaying the same playbook. He thought it was comical, but for Congressman Thanedar, it is an opportunity to highlight those divisions so he can fend off his opponents in the primary. And finally, I wanted to check in with Dave Dulio, professor of political science at Oakland University, about his reaction to the articles of impeachment and if he thinks it could go anywhere. The Supreme Court's ruling emerged from months of sustained litigation over Trump's immigration enforcement policies and other executive actions that exceeded the boundaries of presidential authority. Courts at multiple levels had already determined that Trump was violating federal law, that his policies went far beyond what Congress had authorized, and that he needed to cease his unlawful conduct and restore the legal protections that his administration had eliminated. Trump appealed.
Quote, at least 35 times since August, federal judges have ordered the administration to explain why it should not be punished for violating their orders in immigration cases. For instance, one judge ordered an immigrant be released from custody in Minnesota, but instead the man was let go in El Paso. The Times says this has come up multiple times in California, Texas, Florida, Massachusetts, Michigan, New York, West Virginia, and Puerto Rico.
The court ordered him to comply with the law, to reinstate the policies he had illegally terminated, and to take affirmative steps to return individuals who had been removed from the country in violation of court orders. This was not a suggestion. This was not a recommendation for further consideration. This was a direct and binding order from the institution that serves as the ultimate arbiter of constitutional meaning. Trump's response to this order represents something that has never occurred in American history. No president has ever openly refused to comply with a direct Supreme Court ruling.
To announce that last night, I called for the impeachment of Donald John Trump, President of the United States of America, for threatening judges and for calling for the execution of members of Congress. If ever there was a person who ought to be impeached, it's Donald John Trump. Now, there are many people who don't want to see this happen. They don't want to vote for impeachment. Well, there were people who didn't want to cross the Edmund Pettus Bridge, but they marched on. I shall march on. I've been told that this vote will take place sometime after 1:30 today.
The norm of compliance has been so fundamental to the operation of American government that it was simply assumed part of the unwritten Constitution that everyone understood, even if it was never codified in statutory language. Presidents have criticized court rulings. Presidents have sought legislative remedies to overturn decisions they disagreed with. Presidents have, even in the most extreme cases, expressed frustration with judicial constraints on their authority. But no president has looked at a Supreme Court order and said he will not do what he is being told to do. That step, that crossing of the line from criticism to defiance, transforms a political dispute into a constitutional crisis of the highest order.
There is a big divide between the two parties. And the major stumbling block is the health care coverage. What Republicans are trying to do is throw off 10 million people off of health care coverage. What does that mean is that when you go to the hospital to get chemo treatment or go to the prescription to buy your insulin, your health insurance will not cover some of these costs. The cost of essential goods are going up because of President Trump's tariff policies. But now the healthcare costs are going to skyrocket.
Representative Thanadar's statement carries particular weight because it comes from a member of the legislative body that possesses the exclusive constitutional authority to initiate impeachment proceedings. Congress is not a passive observer of presidential lawlessness. Congress is the institution the founders designated as the check on executive overreach, the body empowered to remove a president who abuses his office or violates his constitutional obligations. Thanadar is articulating what the Constitution already provides, that when a president refuses to follow the law, when he openly defies another co-equal branch of government, when he undermines the foundational structure of separated powers, Congress has both the authority and the duty to act.
So many people would lose their jobs, and as President Trump is talking, they may permanently. So it's going to be a lot of hardship. Currently, life is tough. You know, prices of essential goods have gone up. Healthcare is more expensive. You have bigger, higher copays. And many federal workers could be without jobs for good. And that is going to hurt.
Impeachment is not merely an option in such circumstances. It is the specific remedy the constitutional design contemplates for precisely this kind of crisis. The Democrats who are drafting articles of impeachment, building the evidentiary record, and rallying support among their colleagues understand the stakes with perfect clarity. Every day that Trump persists in his defiance is another day of constitutional violation. Another day in which the president demonstrates that he considers himself above the law. Another day in which the separation of powers that protects American liberty is weakened by the example being set. They are moving with deliberate speed because delay itself would constitute a form of complicity, a signal that Congress is willing to tolerate what the Constitution forbids. The preparations are advancing through multiple channels simultaneously. The legal framework is being constructed, the political support is being organized, and the public case is being articulated in terms designed to reach beyond the Democratic base to independents and even Republicans who may be troubled by what they are witnessing. This will represent the third impeachment of Donald Trump, a fact that by itself illustrates the extraordinary nature of his presidency. During his first term, the House of Representatives impeached him on two separate occasions. The first impeachment addressed abuse of power and obstruction of Congress related to his efforts to pressure Ukraine into investigating his political rivals. The second impeachment addressed incitement of insurrection following the attack on the Capitol. In both instances, the House voted to impeach, but the Senate failed to reach the two-thirds threshold required for conviction and removal. Trump has consistently treated those impeachments as vindication rather than condemnation, arguing that the failure to convict proved the entire process was nothing more than a politically motivated persecution. But the circumstances surrounding this third impeachment are fundamentally different in ways that may alter the political calculus that protected him in the previous proceedings. The previous impeachments involved contested facts and disputed interpretations that provided cover for Republicans who wished to defend the president. Whether Trump's call with the Ukrainian president constituted a quid pro quo, whether his speech to the crowd constituted incitement, these were questions about which reasonable people could construct arguments on both sides, even if the weight of evidence pointed strongly in one direction. But the defiance of a Supreme Court order is not subject to interpretation. The court issued a ruling. The ruling directed specific actions. Trump has publicly stated he will not comply. There is no factual dispute to litigate, no ambiguity to hide behind, no reasonable interpretation under which the president's conduct can be reconciled with his constitutional obligations. The clarity of the violation makes defending it extraordinarily difficult, and that difficulty may translate into Republican votes for impeachment that were not available in the previous proceedings. The constitutional crisis that Trump's defiance has created goes to the heart of how American government is supposed to function. The structure established by the founders distributes power among three branches, each with its own prerogatives and each with the capacity to check the others. The legislative branch makes the laws, the executive branch enforces them, and the judicial branch interprets them and resolves disputes about their meaning. This arrangement depends entirely on mutual respect among the branches, on the understanding that each will acknowledge the other's constitutional roles and will comply with the decisions those other branches make within their respective spheres. When a president declares that he will not comply with a Supreme Court ruling, he is not merely disagreeing with a particular decision. He is rejecting the premise that the judicial branch possesses any authority over him at all. He is asserting that his power is limited only by his own judgment about what is appropriate, and that assertion is fundamentally incompatible with constitutional governance. The enforcement problem that courts face makes this crisis particularly acute because it reveals the ultimate dependence of judicial authority on the willingness of other actors to respect it. Courts can issue rulings and orders, but they have no independent mechanism for compelling obedience. They cannot deploy armed forces to seize control of executive branch operations. They cannot physically force a president to sign documents or issue directives. The power of the judiciary depends entirely on the willingness of the other branches to comply voluntarily, on the shared understanding that the rule of law requires submission to judicial resolutions of legal disputes. When a president breaks that understanding, when he demonstrates that he will not comply voluntarily, the only remaining enforcement mechanism is the one the Constitution provides. Congress must step in and use its impeachment power to remove the lawless president from office. That is the circuit breaker in the constitutional design, the fail-safe that activates when the normal mechanisms of compliance break down. The specifics of what the Supreme Court ordered are essential to understanding both the gravity of Trump's defiance and the human consequences of his refusal to comply. The litigation that produced the court's ruling centered on immigration policies that Trump had implemented in defiance of statutory limits on executive authority. His administration had engaged in mass deportations without providing the hearings that federal law requires. They had detained individuals without the procedural protections that Congress had established. They had denied asylum claims without conducting the evaluations that due process demands. Multiple federal courts examined these practices and concluded that they violated immigration law and constitutional due process guarantees. The courts ordered the administration to stop certain enforcement actions, to reinstate the protections that had been unlawfully eliminated, and to work toward bringing back individuals who had been deported in violation of their legal rights. Trump exhausted his appeals, taking the case through every level of the federal judiciary until it reached the Supreme Court. And when the Supreme Court ruled, it affirmed what the lower courts had found. Trump's immigration policies exceeded his statutory authority and violated the law. The court ordered him to comply with the lower court rulings that had been upheld. Specifically, the court ordered him to reinstate policies that provided legal protections for asylum seekers, to cease deporting individuals without providing them the hearings to which they were entitled, and to make meaningful efforts to locate and return individuals who had been deported in violation of court orders. These were people who had valid legal claims to remain in the United States, people who should have received hearings before being removed, people whose due process rights had been violated when the administration rushed them out of the country before their cases could be adjudicated. Trump's stated reasons for refusing to comply do not withstand even minimal scrutiny. He claims that immigration enforcement falls within the inherent authority of the executive branch, that the president possesses broad discretion over how to enforce immigration laws, and that courts lack the power to tell the president how to exercise that discretion. There is a kernel of legitimate legal principle buried within this argument. The executive branch does possess prosecutorial discretion, the authority to decide which cases to prioritize and how to allocate limited enforcement resources. But prosecutorial discretion is not a license to ignore the law entirely. It does not permit the president to violate statutes that Congress has passed or to disregard court orders that have been issued pursuant to those statutes. When Congress establishes immigration procedures and protections, the president must follow them. When courts determine that the president is violating those procedures and protections, the president must comply with the judicial determination. The claim that executive discretion overrides these constraints is not a legal argument in any serious sense. It is a claim of dictatorial authority dressed in the language of constitutional interpretation. The deportations that the Supreme Court specifically addressed represent cases where the harm to individuals is both severe and potentially irreversible. These are human beings who possessed valid legal claims to remain in the United States, asylum seekers who feared persecution in their countries of origin, individuals who should have received hearings before any removal action was taken. The Trump administration deported them anyway, rushing them through the system before their claims could be evaluated, sending them back to countries where they faced precisely the dangers they were attempting to escape. The courts determined that these deportations were illegal, that they violated both statutory law and constitutional due process, and that the government had an obligation to attempt to locate these individuals and bring them back so their cases could be heard properly. But executing that obligation is extraordinarily difficult. People who have been deported to dangerous countries, particularly those they were fleeing, often go into hiding. Some may have been killed or imprisoned upon their return. Some may be impossible to locate through any reasonable effort. The harm caused by the illegal deportations may be irreparable, and Trump's refusal to even attempt compliance compounds that harm by demonstrating contempt for the individuals whose rights were violated. The constitutional basis for impeachment in these circumstances is as solid as any that can be imagined. Article 2, Section 4 of the Constitution provides that the president shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. The phrase high crimes and misdemeanors has been the subject of extensive scholarly debate since the founding era, but there is broad consensus that it encompasses serious abuses of power that threaten the constitutional order. Defying a Supreme Court order falls squarely within this category. It is an assertion that the president is not bound by the law, that judicial determinations can be ignored at the president's pleasure, and that the separation of powers is optional rather than mandatory. The founders were explicitly concerned about the possibility of a president who would refuse to respect the other branches, who would accumulate power by disregarding constitutional constraints, who would behave as a monarch rather than a constrained executive. They placed the impeachment power in the Constitution specifically to address that danger. And the circumstances they feared are precisely the circumstances that have now materialized. House Resolution 353, the impeachment resolution that has been formally introduced, constructs its case with careful attention to constitutional standards. It details Trump's defiance of the Supreme Court order, documents his public statements refusing compliance, traces the pattern of conduct that demonstrates he is acting deliberately rather than inadvertently, and argues that this conduct constitutes high crimes and misdemeanors that warrant removal from office. The resolution has entered the committee process where the House Judiciary Committee will conduct hearings, gather testimony, investigate the underlying facts, and ultimately vote on whether to recommend articles of impeachment to the full House. If the committee votes to recommend impeachment and if the Democratic majority remains unified, impeachment will pass the House on a simple majority vote. That is the threshold that was met in both of Trump's previous impeachments, and there is little reason to doubt it will be met again. The Senate presents the real challenge, as it did in the previous proceedings. Conviction and removal require a two-thirds vote of the Senate, which means that at least some Republicans would need to join all Democrats to reach the necessary supermajority. In Trump's first two impeachments, Republican unity held. No Republican senator was willing to break ranks and vote to convict, and Trump was acquitted both times. But the political dynamic surrounding this impeachment differs in ways that could fracture that unity. Defending Trump against charges involving disputed facts or ambiguous legal standards was uncomfortable but manageable for Republicans who wanted to remain loyal. Defending a president who is openly refusing to follow a Supreme Court order is a fundamentally different task. The conduct is not disputed. The legal obligation is not ambiguous. The threat to constitutional governance is not theoretical. Republicans who vote to acquit will be voting to endorse the proposition that presidents can ignore court rulings they dislike. And that proposition is deeply unpopular with the American public, including with significant portions of the Republican base. The political calculation that Republican senators will need to make is intensely difficult. Voting to convict Trump would invite the fury of his most devoted supporters and could trigger primary challenges that end political careers. Voting to acquit Trump would provide Democrats with devastating material for general election attacks and could alienate the moderate and independent voters who decide competitive races. Each senator will need to weigh these competing risks and determine which course of action offers the better chance of political survival. For some, particularly those in swing states or districts where Trump's brand has become toxic, the calculus may favor conviction. For others, particularly those in deeply red states where Trump's endorsement remains essential, the calculus may favor acquittal regardless of the constitutional principles at stake. The historical parallels to previous presidential defiance of the judiciary are illuminating, but also demonstrate how far beyond established norms Trump has traveled. The most commonly cited example involves Andrew Jackson's response to the Supreme Court's decision in Worcester versus Georgia, which held that Georgia could not enforce its laws on Cherokee tribal lands. Jackson allegedly remarked that Chief Justice John Marshall had made his decision and could now enforce it himself, and Jackson proceeded to disregard the court's ruling. The consequences were catastrophic, leading directly to the Trail of Tears and the forced removal of Native Americans from their ancestral lands. Jackson's defiance has been condemned by historians as one of the most shameful episodes in presidential history, an example of executive lawlessness producing humanitarian disaster. Trump is now walking the same path Jackson walked, refusing to enforce a Supreme Court ruling he opposes, and the consequences for the individuals whose rights are being violated are similarly grave. The difference is that the impeachment mechanism has been strengthened since Jackson's era, and Congress has both the constitutional authority and the institutional capacity to hold Trump accountable in ways that Jackson never faced. The enforcement problem that the courts confront when dealing with a defiant president reveals the ultimate fragility of judicial power and the essential role that other institutions play in sustaining the rule of law. The Supreme Court can issue rulings and orders, but it cannot independently compel obedience. It cannot dispatch law enforcement to take control of executive agencies. It cannot physically force the president to comply with its directives. The court's authority rests entirely on the expectation of voluntary compliance, on the shared understanding among all branches of government that judicial decisions must be respected even when they are unwelcome. When a president shatters that expectation by openly refusing to comply, the court has no internal mechanism for responding. It must look to the other branches, specifically to Congress, to enforce its judgments through the powers the Constitution provides. Impeachment is the enforcement mechanism of last resort, the tool the founders placed in the Constitution for precisely the situation where a president refuses to accept the constraints that the law imposes. The Democrats who are advancing this impeachment understand that they are answering a call that the judiciary cannot make explicit, but that the constitutional structure implies. The court has ruled, the president has defied. The judiciary has done everything within its institutional capacity. Now the obligation shifts to Congress, and the question is whether Congress will fulfill its constitutional responsibility or allow the defiance to stand. The answer to that question will define what kind of government the United States actually has, whether the Constitution means what it says about separated powers and presidential accountability, or whether those provisions are merely aspirational language that imposes no real constraints on executive behavior. The timing of this impeachment process intersects with the broader political calendar in ways that amplify its significance and its potential consequences. The midterm elections are approaching, and every member of Congress will need to face the voters and explain their decisions. A vote to acquit Trump will be presented by Democratic challengers as a vote to endorse presidential lawlessness, a vote to place loyalty to one man above loyalty to the Constitution. That message will be particularly effective in competitive districts where swing voters may not follow the details of every political controversy, but can understand the simple proposition that presidents should follow court orders. Republican members who are already facing difficult re-election campaigns may conclude that voting to acquit is simply too risky, that the political cost of defending Trump's defiance is higher than the political cost of breaking with him. The possibility of actual conviction and removal, while still a heavy lift requiring 17 Republican senators to join all Democrats, is more plausible in these circumstances than it was in either of the previous impeachments. The clarity of the violation changes the political calculus.